Okay. Looks like we are live here. Hold on. Let's make sure we're live.
I need to scoot in here.
All right, man. This is our first live on the page.
Yes, welcome to everyone.
Yeah. Let's turn
watching.
this a little bit so we can at least see us both. We're technical difficulties. We're figuring this out as we
Got a
go.
lot of camera angles.
All right.
All right, welcome in everybody. We're here to talk a little bit about what the FTC has came out with in their final ruling on April 23rd of this year, which is the non-compete ban.
Yes.
We've been getting a ton of questions on it.
Yes.
We've had a lot of clients, as soon as the first day came out, they started asking, are we throwing out all of our agreements?
Yeah.
Are we do we need to just trash everything and start over? What does this mean? Our business is going under. So Rocco, what did come out on April 23rd?
Well, so the FTC issued, I think it was in January, they had a proposed ruling out on banning non-compete agreements because they said it was a restraint on trade. And the FTC has powers promulgated by Congress to monitor and oversee trade within the United States. However, I think they took some liberty with this one. So they had it in January, the proposed ruling went out for public comment, and then they just voted on the final rule. And I think it was a 3-2 vote.
Yeah.
It went into effect. So in essence, they're saying non-competes are a restraint on trade, and you can no longer have them. So you can't put them into new agreements. You have to tell your employees, other than ones that qualify as senior executives, that you're not going to be enforcing them against them.
Mm-hmm.
Now, this does not impact any non-competes that are currently in litigation. That's one of the big, because we've had clients ask that are in active litigation.
Mm-hmm.
Whether that impacts that, it doesn't. I do believe the rule has already been challenged and will be challenged. You have, I think it's 120 days from the date the rule went into effect, which was April 23rd,
Mm-hmm.
to actually comply. So you have to send notices to your employees, and there's a lot of pieces to it. And reading through the ruling they put out, I believe the FTC already anticipates litigation because the majority of their rule was their legal argument they would make as to why they have the authority to do this.
Yeah, so you touched on a lot there.
Yeah, I tend to do that sometimes.
So you brought up executives.
Yes.
And this was an interesting caveat that the FTC made. So for existing non-competes
Mm-hmm.
with executive level employees, they have a two-part test. They have it's a salary requirement.
Yeah.
And a job duties requirement. So kind of as we're going through this process, we just keep identifying, what's going to be litigated. What do we anticipate to be litigated? So I think this one is ripe for litigation because existing non-competes with senior level executives will still be valid if they hit these two-part tests. One is they make a certain amount. I think it's 150.
It's 151 and change, I
Yeah.
believe is what the number is.
And then the second piece was this job duties test, which is, are they in a policy-making position?
Which is the most vague term, which is, again, this is the problem with the government when they put rules in place and don't think of the unintended consequences.
Yeah.
There was nothing that I've read in that ruling that describes what that actually means and how you can say yes or no.
Yeah.
It's going to be a lot of arguments made because again, it comes down to a lot of companies, non-competes are not right. They're not right for everybody. It doesn't make sense to have a non-compete for your low-level employees. Most of non-competes are for senior executives, right? Because they're privy to confidential information. They're privy to the way a business operates. So they want people to not go work for competitors. So yeah, a lot of senior executives fit the salary test. Mm-hmm. But policy making, what does that even mean?
Right.
If I am the controller of an organization, am I making policies? Typically the CFO is doing the accounting policy making. Mm-hmm. I'm just implementing the tactical side of it, but I'm still a senior executive. So if I have a non-compete and I don't fall in the second part of the test, I could go work for a competitor and let them know how we run the business from an operational standpoint, except for other restrictions you could put in place.
Right. Now, and again, what's important is this only applies for existing non-competes.
Correct.
So even moving forward,
Mm-hmm.
they're still banning
Yeah, you can't.
non-competes.
Yeah, you can't have them on senior executives moving. So if you hire a senior executive now,
Right.
you can't put a non-compete in place. But if you have a senior executive that's subject to a non-compete on, prior to April 23rd, and they fit both parts of the test, then yes, you can still uphold that non-compete against them.
Okay, so I want to move forward because there's one question I think we've been getting a lot,
Okay.
which is we have gotten calls asking, are we throwing out all of our restrictive covenants? Are we throwing out, basically, as soon as we hit the restrictive covenant page of our employment agreement, we can just basically X out everything underneath there.
Right.
Is that the case?
No, and again, that's a good point, because let's talk about what a restrictive covenant is. That is a term of art in the legal industry that is a restraint on what an employee can and can't do. The FTC said you can't stop an employee from working for a competitor or working within an industry. That doesn't mean you can't stop an employee from taking your customers, taking your employees, or taking your confidential information. Those are really the three other ways to protect yourself as a business, right? Very strong non-disclosure agreement and confidentiality provisions, so you can't steal trade secrets. Non-solicitation provisions that say, hey, I don't care who you work for, just don't take my employees and don't take my customers.
Yeah.
That's really what's still in place.
And again, as we were talking at the beginning with senior executives, areas where we see there's going to be some litigation. This next piece is with the restrictive covenants. While non-solicitation NDAs are still valid, they cross over into the gray area and could be banned if they functionally operate as a non-compete.
Yeah. And again, that's a hard one to really get into because it's so gray, right? And look, that's why lawyers are in place, right? We argue in the gray.
Yeah.
And so what that really means is that provision written in such a way or so preventative in such a way that in essence that employee couldn't work for someone else?
It needs to be so broad and so onerous that it in effect is a non-compete in and of itself.
Yeah, and I'm trying to even think of an example. If you are a company that works in a very small niche industry, that maybe there's 10 major customers in the United States, and you say, hey, we don't have a non-compete with these people, but they can't work with our customers. And there are really only 10 customers that buy this product. Maybe it's a defense product or something. That, in essence, I think the argument could be made that restriction is operating as a non-compete. And under this FTC rule could possibly cause a problem.
Yeah. There's a lot of unintended consequences that the FTC didn't think about here.
Yeah.
One being, or I shouldn't say one, I should say another one being the unintended costs of litigation, because non-competes, although can be costly to litigate, the cost now of an expansive NDA, an expansive non-solicitation agreement that is now getting into the gray, that is going to be, in my opinion, much more costly to get through in litigation because you're arguing essentially in the gray, whereas non-competes you can make a bright line test of 50-mile radius. It's got to be within 12 months. You have checks and balances there where you have markers.
Correct.
Did someone what qualifies as someone just learning general information and general knowledge in a job versus you trained me specifically for my position, and now you're taking that proprietary information elsewhere? How do you draw the line there?
That's a hard line to draw. And I think the other unintended consequence of this is when I look at a non-compete, and I had discussions about this in the past couple of weeks, non-competes are really preventative measures, right? If you are an employee that I'm trying to hire from a company, one of the first questions that people would ask prior to this ruling is, do you have a non-compete? And if you do, I'm not going to hire you. I'm going to say wait it out or figure it out, because I know that if I know you have a non-compete and I induce you to come work for me and breach that, I am now potentially on the hook for a tortious interference claim. So non-competes were very much a preventative measure that, hey, we don't want to hire you. You have this non-compete. It's not going to work out. However, take those away, same thing like you said, you have a non-solicitation. Okay, just don't call your customers. Come work for us.
Right.
Tell us the general knowledge. Just don't
Right.
contact any of the customers you dealt with while you were there. After that year's over, fair game.
Yeah.
That's the scary part of all this.
Yeah. I mean, we have a lot of contractors as clients,
Mhm.
and if you think about you bring in a contractor, they learn your bid process, they
Yeah.
learn your cost structure, they learn all of your technical approaches.
Mhm.
On day one,
Mhm.
they can just leave, go straight to the competitor, get a great salary increase,
Yeah.
and use that knowledge.
Yeah.
And now it's on the company to try to prove that they took that information.
Mhm.
And that's a very hard thing to track.
Yeah, and it's hard to track, and that type of litigation is expensive, right? Because you're doing an injunction or filing a temporary restraining order. You're
Yeah.
trying to, when there's a breach of a restrictive covenant, a non-compete, non-solicitation, non-disclosure, the first thing it comes to do is file an injunction. We don't know what our damages is yet. We just need to stop you from doing what you're doing because the damages could get so high. That is an expensive process from a litigation standpoint because it's quick moving, it's a ton of work up front, and there's no guarantee it's going to work, but you have to do it because you're saying, I have such a business interest to protect by these restrictive covenants, and you've breached that, I have to enforce that because the flip side of that is if you can't really cherry pick who you enforce them against.
Yes.
Because the whole basis of a restrictive covenant is I say I'm a business, I have a legitimate business interest to protect. That's why I have these restrictions. But if I'm not enforcing that against everybody, I would make the argument and I said, how legitimate is that interest? You're cherry picking who you enforce it against. That's a BS answer. So this rule, it does not sit well with me.
Yeah.
I think it's definitely being challenged. I can see an injunction happening within the next month or two, either overturning it or delaying the implementation of it.
Well, I mean, we can just dive right into it. That's my next question.
Mhm.
I mean, I know of two already challenges
Mhm.
that are already in process. So, what do you expect, or expand on it a little bit more?
Mhm.
You brought up the fact of someone coming forward with a challenge and an injunction. What would that mean for the audience and folks
Mhm.
that have non-competes right now? If that injunction is upheld, what does that look like for the landscape?
Yeah, so if they say, if a court says there's a nationwide injunction on this, then you don't have to provide notice to your employees that you're not enforcing it. And I think it'll depend on how the opinion is written, whether or not they can still have non-competes going forward.
Mhm.
That's the real gray area, right? Because if they have an injunction, because the enforcement is you have 120 days to comply, meaning, and in that 120 days, you have to provide notice to your employees that are subject to a non-compete that you're not going to be enforcing it against them.
Yeah.
So if the injunction says, hey, we're just delaying the implementation of the notice period, then you still can't have non-competes right now, but you don't have to notify your people that currently have them that you're not enforcing them. So that means people you've hired after that, you can't put a new non-compete in place, but you can still enforce the old ones.
Yeah.
And again, I think it's going to come down to how the court opines on it. I think this is, again, a lot of government overreach. I think the FTC took a lot of liberty with their powers that have been promulgated by Congress to say, yeah, we can, in essence, they're saying, we are smarter than all of you, and we know what's best for everybody. Even though you're two willing parties entering into a contract, we know better than all of you, and you shouldn't do this.
Yeah, I mean, that's one of the biggest challenges right now that the FTC is facing is their overreach, and them coming out and saying that they can preempt state laws.
Yeah, that's exactly right.
So that's probably one of the biggest challenges that they have. And then even beyond that, you have the challenge of even if you can get past this portion of it, can they delegate this to this authority, this rule-making authority, basically coming out and saying, can't have non-competes, we're going to enforce this particular rule. Under the Constitution, can they delegate that power? So that's another huge issue that the FTC is going to be facing here.
That's a good question. I didn't even think about that from the constitutional standpoint, like the delegation of the, because again, it's a federal agency, right? are they an enforcement agency? Like, do they have the power to penalize? Do they have the power to cite violation of this? And again, they're now trumping state law, when in essence, state law should trump federal law. If state law is more protective, it should always trump federal law, right? That's how the federalist system works. Again, I think this is, it frustrates me because I think there was a better way they could have done this. If they truly thought that non-competes were and they're saying it's going to help startups and help people move through industry. But if they really wanted to say, okay, if you're going to do this, it's bad. But if you want to do it, here's what you have to do. Like we talked about before, have a provision that says if you want to have a non-compete, the consideration of the job itself is not enough. You have to provide additional consideration at the time of employment to have an enforceable restrictive covenant as a non-compete. So meaning if I'm gonna hire you, I'm gonna pay you $100,000. That, because the way a non-compete works prior to this rule is that you have to give consideration in exchange for a restrictive covenant. So the consideration when you join a company is the job itself, the compensation. They could say that's not enough. You have to give some sort of bonus. Make it a percent of your salary. Say, okay, if you want to have a non-compete, you have to be willing to pay somebody 10% of their starting salary to have an enforceable non-compete. Simple solution in my opinion, but again, the government overcomplicates things.
Yeah, you touched on something, it's going down a different road, but we have run into this with clients in the past. Continued employment is not enough consideration for a non-compete. We've had employers bring in folks, hire them, they've already started, they're a month, 2 months in, and they said, oh, you know what, sign this document too, it's a non-compete, don't worry, if you don't sign it, you're fired. That's continued employment is not consideration. So keep that in mind. Again, that's going down a different path of what we're here to talk about.
But that's actually a good point to bring up because non-solicitation agreements are still going to play into that space, right? And,
absolutely.
And that's something that you have to understand because it has to be, in courts look at it, was the signing of the non-compete contemporaneous with the start of employment? And there's no real time period. I remember when coming out of law school and the first job I had, I was involved in a case like this and we looked at this and there's not a timeline. In some courts it says if they sign it within 3 days it's enough. Other courts have said if they sign it within the first 3 months it's enough. So you have to understand, one, the jurisdiction you're in. If you're just as part of their joining packet or part of their employment offer or their employment agreement, just have those provisions in there and you avoid this problem. But it's something to always be cognizant of when they're signing these restrictive covenants, including non-disclosure agreements. At the time of employment, or are they signing it afterwards, and is it going to be enforceable if it's after?
So let me ask you this, because what are your thoughts? Because I see a comment out there, but you guys are listening to two blind people. We barely can read anything on the screen, but we did have a question.
Comments. That's far away, man.
So I can only see the digits. So what are your thoughts on non-competes and 1099s? Because you're going down a whole different path and road of potential issues. Again, we're going down, this is a little bit different than FTC regulations, but I think that there's a worthy discussion to be had here.
100%. So one, let's start with the FTC did include contractors in the ruling. But two, having a non-compete with a contractor, in essence, makes them not a contractor. That's what people have to understand. If you have a non-compete with a 1090, and there's no such thing as a 1099 employee. I've had this discussion 1,000 times in my legal career, and it's a misnomer out there that people just think that's how it's phrased. It's either you're an employee or you're a 1099 contractor. And what that means is I don't control you or how you work. I just need a result done, and you give me the result in exchange for money. In fact, in March, the test that the Department of Labor looks at for independent contractors actually changed, and now to be a true independent contractor, they in essence have to be running their own business, meaning they are free to work for anybody. They can make a profit or a loss. They're not just working for you. Even if you say they're a contractor and you have an agreement in place and they fit all the other pieces, but they've only ever worked for you and never went and tried to get work from anybody else, the Department of Labor could potentially say that's not a contractor, that is an employee, regardless of all the other factors that were hit. They're still, in their eyes, an employee. And by putting a non-compete in place With a 1099 contractor, you are in essence saying they're not a contractor because you're restraining their ability to work.
Yep. That's exactly what I wanted to hit on, because, like I said, I saw the numbers out there. I saw the numbers out there, and I wanted to just touch on that big discrepancy, because we do get that a lot.
It's a big question. Absolutely, it is.
So, knowing that now, and obviously what we've had some pretty in-depth conversations with clients at this point. So, we can't dive into it all right now, but just some high-level thoughts on knowing the gray area, knowing all the questions that are coming up. What do we do? I'm a business owner. What do I do now?
I would say pause. Don't put non-competes in place with new employees, right? Unless it's if you think it's an absolute must, talk to your lawyer first. But don't notify employees yet. That's what I think, because we don't know what's going to happen. Yeah. And you don't want to, because we have 120 days, so that's April 23rd, so add 4 months to that. So that's August, like towards the middle of August. Yeah. You have until then. Yep. So we'll know something way before then. So I would say don't notify your employees about anything yet. Yeah. Just pause for a second. I think that's what most firms are advising their clients. Like, just pause. Like, we don't need to do anything right now, because we don't know. This could change very quickly, based upon these injunctions or these lawsuits, because again, this is the same thing that happened with the CTA, the Corporate Transparency Act, right? That's a whole other topic, but when the government starts taking liberty with the powers they are given, businesses challenge it. Yeah. And then courts step in and say, does this agency actually have the power to do what they are doing? And if not, that's when they say pause. Nope, we're not going to do it. Overturn it. So we don't need to. We shouldn't be doing anything yet. No notifications going out. Just pause and take a breath. Yeah, and to add to that, because I do think, one, hitting the pause button, taking a breath. Let's let the dust settle, because we are just starting. This is the tip of the iceberg for this. Absolutely. FTC has a very enormous battle ahead of them. Yeah. But beyond that, I would say do not make any fundamental changes yet. So take an accounting. If you have non-competes in place, what are those? Start collecting them as a business, and then start making the connection, because you may need to at some point in time down the road. Was there a business justification for that non-compete? Yeah. Because who knows what the FTC is going to say. But even if we put that to the side, states are already cracking down on non-competes. Yeah, absolutely. So regardless of what happens with the FTC, we're still going to have discussions on non-competes. I mean, there's, I think, 3 states already that has banned non-competes already. Yeah. So, and I know Pennsylvania, courts definitely lean to one side over the other, depending on what the restrictions are. So what I would say as a business owner, collect all of your non-competes, review them, see if you can make that business justification, that connection point. Yep. And then moving forward, if you're bringing in, because this is an important part, if you already have employees that are subject to non-competes, and you start hiring people, and the FTC takes this away, but you don't subject the new hires to non-competes, then you have this gap, because like you were saying about cherry picking, now let's say you have 10 employees subject to non-competes, but you have 10 employees because you just hired them not subject to non-competes. Therein lies as an issue down the road. And I think that's a good point to bring up, because I think there's going to be a couple ways you're going to have to solve that, right? So let's run through this next. I think it's a really good one. So I have 10 employees. I do this business justification. I say, okay, I have a justification for these 10 employees that have non-competes. FTC says can't have them anymore, right? We didn't notify employees yet. We're hired 10 new people, and we didn't subject them to non-competes because the government told us not to. I think if the FTC rule goes away, you may be able to make the argument by giving them non-competes and saying we were prevented from doing this, was a term of employment. And maybe that's something we look at doing, is when you're hiring people now, say we would normally have a non-compete with you, but because the FTC rule says we can't, it's not in this agreement. If that rule goes away, you will be subject to one. Yeah. Doing that, or at very least, you'll have to pay some additional consideration. Yeah. Because you want to make sure you're consistently applying it across the board. Yeah. If the rule goes away, then you've got to relook at that and say, what do we do in that situation? Yeah. And it's too early to tell what's going to happen, but it's a really good point to bring up, and I think it's something that people should keep on the forefront of their mind.
Yeah.
Yeah, it's a lot. It's a lot.
There's a lot of
stuff.
information there.
Yeah, and again, this is one of those times where I do believe maybe the FTC had some good intentions behind this, right? And I'm not saying that everything the government does is bad. I just think they took a lot of liberty with this.
Mm-hmm.
When you read the rule in the first 100 pages, are the argument as to why they have the power to do it.
Yeah.
You know that they really are questioning the power that they have to do this. They're already making the argument in the ruling itself, or in the regulation they put out itself, to say, yeah, challenge us. Here's all the authority we have to do this. I just think it's going to be challenged down the road, and it's going to be a wild landscape over the next 3 months, I think.
Yeah, I think we're going to be coming out with updates from now until the fall. There's going to be a lot more information that's coming out, and like I said, the FTC has certainly an uphill battle. Despite the fact that they came out with 570 pages of why they could do this, it's a long road ahead. So, long story short, I think getting everything in place, getting in order, use this as the reason to get all of your documents together, and then just be prepared.
Yeah, and don't panic. Don't panic. Take a breath. This is why you have to have a business lawyer, and not to say we are the business lawyer, but just having a business lawyer to talk to about these things, because I've spoken to people, friends of mine that are in the legal industry, didn't know about this rule. Yeah. So unless you're in these spaces, they don't know. You may not, as a business owner, like I've had a couple clients call that the only reason they knew about it is because the client alert we sent out. Yeah. So think about people that don't have a lawyer they're working with, that don't have a business lawyer, and they just hired someone this week and gave them a non-compete, and they think they're good, like great. What's going to happen there? So it's something you have to. If you are a business owner, you have to make sure you are looking at everything, and that's why having a good lawyer, a good CPA, a good insurance person on your team to kind of help you check through these things is something that it's worth its weight in gold, truly, and it's something that I highly encourage people to do, because the government is taking a lot of liberty with laws and their agencies right now. So this is not the first thing that's going to come out, and then there's going to be so much more in the next 12 months, at least up until the election. I think there's going to be a lot more stuff coming out, so it's something to just be on the lookout for. Well, thank you, everybody. Yes, definitely. Again, we didn't even introduce ourselves, but as we head out, we got Rocco Koza, founder of the Koza Law Group, and then my name is Matthew Bolowitz, partner here at the Koza Law Group. So thank you for joining. I'm sure we have a lot more to come. Yeah, we will be doing these more often, so definitely keep a lookout on the page for more of our lives, and we'll definitely get better at doing them. I can promise you that. Less technical difficulties next time. We'll see. Thanks, everybody. As I'm sitting here touching the screen on my computer. That was good. That was a good one.